Okay, so for listings, first thing we're gonna do is I'm gonna do a pretend listing. We'll pretend like it's, you know, we'll just make them address for it basically. So you're gonna go in Zip Forms to new listing, and that's gonna ask you to create a file. So you could do it by your client's name or you could do it by the property address. For this one, we'll just do 1234 Apple Lane, and we'll say it's in Concord, NC. You click residential and then save. And so it takes you automatically into your portal. So you can fill all of this information out if you want to, totally up to you. I don't ever fill it out because all this has to be filled out in the SkySlope anyway. I basically use this because I like this for my documents. So you're going to go to your documents and you'll see that it'll apply the template of everything that you need for a listing most of the time. If for some reason this stuff isn't here, it's the same as always. You're going to go to all forms. You're going to make sure you have your working with real estate agents. You're going to make sure you have your exclusive right to sell. And you're going to make sure you have your property disclosures, mineral, oil, and gas. If the property was built 1978 or before, you're going to do your lead-based paint addendum too. So we know how to do working with real estate agents. So we're going to go in and do the exclusive right to sell listing. So you open it up and you can write, and we'll say our sellers are John Smith and Jane Smith, if I can type this morning, and Jane Smith. And then the firm is going to be eXp Realty, and it comes down, and you're basically, this top portion right in here is stating, hey, this is a contractual agreement entered into between John and Jane Smith and eXp Realty as the firm. It's going to be deemed to include the agent that is signing this agreement and any other agents in the firm too. So if the property was most recently owned by a person who is now deceased, the tax listing or last recorded deed to the property may not accurately identify the parties who should be named as the seller. In such a case, the deceased owner's will or applicable North Carolina law, if deceased owner died without a will determine the correct parties to sign the agreement. So anytime, and I know this doesn't pertain to you, Merida, but anytime you have an estate or something like that, you're going to want to consult with an attorney on who needs to sign the agreements. Even if they have a will and everything like that, you always need to consult with an attorney to make sure that, hey, do I have everybody on here that needs to sign? So you come down, it says the term of this agreement shall begin on its effective date and end at midnight on the expiration date. And the effective date of this agreement becomes between the seller and the firm's respective rights and obligations shall commence as follows. So you could put the effective date shall be the date that this has been signed by both the buyer and or by the seller and the firm agent. Or in situations where the listing is currently marketed with another firm and it's set to expire, you can put whatever date that previous listing expired on. Note down here, according to Article 16 of the Realtors Code of Ethics, which we're all realtors, realtors shall not engage in any practice or take any action inconsistent with the exclusive representation or exclusive brokerage relationship agreement that other realtors have with clients. So what that means is even if you sign this agreement and you click the property is currently listed for sale exclusively with and expires, it means that you cannot do any type of marketing until that expiration date. So say this expired on 4/18/2020. So at midnight on 4/18/2020, that is when you can begin marketing the property under your listing agreement. So down here, you're going to put the street address, 1234 Apple Lane. We'll say it's in Concord for the city. We'll just do 28025. And then county, Cabarrus, or whatever county it is. And then your expiration date. The agreement shall terminate at midnight on. So you will get a lot of different feedback on how long you should make a listing agreement for before. My rule of thumb is normally a year. you're investing marketing dollars, photography dollars, time, effort. So you want to make sure that you give yourself enough time. If the seller is balking at a year and they don't want it to be a year, I highly suggest you go into MLS and find out what the average days on the market is in that area and make it for at least 2 months longer than that. And that way you have some kind of recourse when he's like, oh no, I only want to sign 3 months. You can say, Mr. and Mrs. Seller, the average days on the market here is 4 months, or something to that effect. So right here, I see I'm going to put in 04/18/2021. That's when I want my agreement to expire. I want a full year to market this property. Then you come down and it's asking for your plat reference, your lot unit, your block section, subdivision, the property ID, and other description. All of this can be found in Matrix. So if you're in Matrix and you're like, where do I find all of this information? Some of it will be there and some of it won't. Say, for instance, we were doing 4159 Tite Road in Stanfield. The parcel ID is going to be the same as the PIN. So I would copy that. Now, if for some reason you don't have a listing, you can go into tax records and you can get all of this information from there too. So we're coming in once my computer loads, and I'll just use my address as an example. So I put in the address, it pulls up my tax card. Eventually, it's going to pull up my tax card. And we come down, you can see a lot of information, your zoning codes, you can see the neighborhood code, what township it's in, all of that information. But if you keep scrolling down, you'll see down here we've got the parcel ID. So you would copy this, and then I'd go back to my listing and put it right here where it says parcel ID. Now, if you wanted to include like the legal description down here, which I highly recommend it, because sometimes numbers can be off, and it'll allow you to make sure you can put the legal description in other. And try to fill this out as much as you can, but don't stress on making sure every single little thing is filled out. If you were the type of person that wants every little thing filled out right here, you're going to need to go in and find the deed on the Register of Deeds website, and that's going to give you your lot unit, your block section. It'll give you what plat book and slide it's on, what deed book and page it's on. You can do a deed search with whatever county that home is in. So Cabarrus County Register of Deeds, Union County Register of Deeds, so on and so forth. You come down, fixtures and exclusions. So you learned your pre-licensing what a fixture is. This is basically telling your sellers, hey guys, these have to convey with the home. So how I explain this is everything we see on this list, Mr. and Mrs. Seller, are things that have to convey with the home. They are considered a fixture in North Carolina, and they convey at no additional price. So is there anything on this list that, one, you don't want to convey, or two, may be leased or you still owe money on? And say they come back and they say, well, yeah, our alarm system is leased, we don't own that, so on and so forth. So I would put down here in items leased or not owned, alarm system. If they were like, hey, we really, really, really want to take the chandelier in the dining room, you would come down and put other items that do not convey, chandelier in the dining room. You want to make sure that they know, hey, it's better to go ahead and replace that chandelier, take it down, replace it with whatever light's going to convey. That way they know exactly what they're getting when they're viewing the home. But if they don't, there's a place in MLS to include exclusions. Personal property, they say, yeah, we want to leave our fridge, washer, and dryer. That's where you would put this. So think of it in terms of if you got a house on the market and you got them a full price offer and the fridge, washer, and dryer and everything, and they balk at the fridge, washer, and dryer, and then they get fed up with you and they say, you're not doing your job. You can always come back and say, I got you every single thing I said I would get you in our contractual listing agreement, right? So make sure that anything you're clicking on this listing agreement, you're doing, because these are your obligations and their obligations. And home warranty. If the seller is going to get a home warranty and pay for it at closing, you can put agrees or you can put does not. It really depends on your marketing plan, what you're going to do. I personally don't advertise home warranties. That's a negotiation tool unless it's a really, really old home or it's a brand new construction home that has a home warranty automatically that we don't pay for. Listing price. So you agree to list the property, we'll say $235,000. So that means, Mr. and Mrs. Seller, if I bring you an offer of $235,000, you are agreeing that you're going to sell it for that, right? And then you look at the types of financing that you're going to take on. So cash, everybody loves cash. Conventional is pretty good. The things you need to be aware of is the FHA, the VA, and the USDA. So for FHA and VA, if you have a really rundown property for FHA, they need to understand that FHA may require certain repairs be done before closing by the seller. Same with VA. With VA, they need to know that typically the sellers are responsible for paying for a termite inspection, and that has to be done before closing. With USDA, how to find out if a home is in a USDA area, you go on Google, USDA eligibility map. You click on USDA eligibility and it goes, welcome to this. Let's see, you come up here. We want single family houses guaranteed. They're going to give you a property disclaimer. You accept it. And you're going to go in and type in the address of the property. And this will tell you if it's USDA eligible or not. And then I will explain to you why this is important. So it is in an eligible area. What you need to do is you need to print this screen out. That is your protection that, hey, at the time of listing, it was in a USDA eligible area. If for some reason it wasn't, this would say is not. So in this, you would put USDA if it was available. Loan assumption. Most lenders no longer allow loan assumption, and I never click on that. If you get an offer for a loan assumption, cross that bridge when you get there and check with the seller's lender to see if it's even able to be done. The reason this is important when you're clicking on what is acceptable, number one, it protects you. If you get a $235,000 offer for FHA, the seller can't suddenly say, well, I don't want to accept FHA. You didn't do your job. No, you agreed to accept FHA offers. But also, when you go to put this listing in MLS, you're going to represent that the property is eligible for certain types of financing. Say, for instance, you put FHA and you get an offer, it gets accepted, you've got due diligence, earnest money, and inspections on the line, and then it comes back that it's not FHA eligible. Well, you as the listing agent represented it was. Sorry for the leaf blowing, my kids are going outside, but you represented that it was. And what could happen, and of course we all know it has to go to court and everything like that, but what could happen is you could be sued and the buyers could say, we want all of our money back because you should have known this was not an FHA property. You represented it as an FHA eligible property and we lost money because of your misrepresentation. So what I suggest is, if you're not sure if it's FHA eligible or VA eligible, do not put it in MLS. You can click here, but don't put it in MLS. Disclose in the bottom that you're open to those, but that you're not going to be liable for any if they're not eligible or not. Buyers should insure beforehand, something to that effect. So you come down and it's firm's compensation. So as we know, guys, fees are negotiable. They're not anything. I charge 6% on my listings. Most of the time. There's very few times that I discount my listing price. I'm not going to say I never do because that would be a lie, but there are very few times. If for some reason you were going to do like a flat fee, or instead of a percentage, it's a dollar amount that they agreed to buy or pay, you would take the percentage out and then you would put, we'll say $5,000 flat fee. And that's where it would go. But in this instance, we're going to do 6%. And then it says if circumstances set out have not occurred, and if within 90 days after expiration, seller directly or indirectly sells or exchanges the property or anything like that to anybody that has seen the property during the term of this listing agreement, that you're still due a commission. I generally do 90 days. That's 3 months. 6 months is a really, really long time. A year is even longer. And I guarantee you're not going to keep up with the property and who all viewed it that long. Fees are due and payable. So once earned as set forth above, the fee will be due and payable at the earliest of distribution of proceeds from the sale, the seller's failure to sell the property, included but not limited to the seller's refusal to sign an offer to purchase the property at the price and terms stated herein. Remember what we talked about. So remember, guys, like they're saying, if you bring me offer that abides by the terms we're setting out in this contract, I'm going to sell it. So if you do that as their listing agent, you are due a commission, whether the seller wants to sell or changes their mind or what. Transfer of interest in business entity. If the seller is a partnership, corporation, or other business entity, and an interest in the partnership, corporation, or other business entity is transferred, whether by merger, outright purchase, or otherwise, in lieu of a sale of the property, an applicable law does not prohibit the payment of a fee or commission. So what that means is, say you took on a listing for a company that was building houses, right? And suddenly the company decides, hey, we're going to change our name, and Jonathan's not going to be a part of this company anymore. And so we don't have a valid listing agreement anymore. I'm not paying you anything. What this is saying is that, no, they still owe you money. They can't just change their name or transfer partnership interest or anything. This listing agreement conveys with any kind of change within the business itself. Additional compensation. So if additional compensation, incentives, bonuses, rebates, or any other valuable consideration is offered to the firm from any other party or person in connection with the sale of the property, the seller will permit the firm to receive it in addition to the fee the seller is agreeing to pay. So what this means is, you know, it's really odd that a seller is going to get any kind of bonus from anybody, but say you get a gift card from the home inspector and thanking you for letting him in the listing. The seller can't say, well, that gift card was worth $50. You need to deduct that $50 off of your commission at closing. Attorney fees and costs. If the firm is the prevailing party in any legal proceeding brought by the firm against the seller to recover any or all fees, firm shall be entitled to recover from seller reasonable attorney fees and court costs. So basically that means is, Mr. and Mrs. Seller, if you don't do what you say you're going to do in this contractual obligation and we have to take you to court, you're not only going to be responsible for whatever the judge says you are, but also our fees and the cost it took us to take you to court. So it says down here, cooperate with sub-agents representing the seller and offer them the following compensation of the gross sales price. EXP does not let you do that. What that basically means is, Mirda, I could come in and I could show your listing and I could take the, and say the buyer doesn't want me representing them. They want to represent themselves. If we clicked cooperate with sub-agents and offer them this price, what would be happening is we would essentially be giving up our commission, is my understanding of it from what EXP said. I've had it where I used to click this and the EXP said we don't offer that. So I never mess with that one. Cooperate with buyer agents representing the buyer and offer them the following compensation. So 3% of the gross sales price, or if it were a flat fee, you'd put it right there. In addition, you're going to cooperate with and compensate other cooperating real estate firms according to the firm's attached policy. Firm will promptly notify seller if compensation offered to the cooperating real estate firm is different than what is set forth here below. Sellers should be careful about disclosing confidential information. So basically you're saying we're gonna give the buyer agent 3% of the 6%, and then we're also saying that, hey, that 3% is going to be going to the real estate firm. This down here basically is about the realtor code of ethics and our fiduciary duties and all of that stuff, and you're holding us harmless for certain things. And then this is also where if our seller came in and said, you are not to show this property to anybody that is Jewish, we would have to be like, you know, that's against the law. I cannot discriminate on anybody based off their race, color, religion, sex, national origin, handicap, familial status, or any party or prospective party to this agreement with regards to ethical duties, so on and so forth. So it doesn't matter what they say. Anybody that wants to view that property, if they are ready, willing, and able, they can view it and they can buy it. You cannot not let them. So commencement of marketing. The firm is authorized to commence marketing the property as described in subparagraph B below on the effective date, which will be the date both parties sign, or in a delayed marketing date. So you get the listing agreement signed, but they're not ready to go live today. What you're going to say is, Mr. and Mrs. Seller, when do you think you're going to be prepared to go live? And they're going to say, oh, May 1st. We just need to get the home clean and ready for pictures. Great. Right here, I'm going to put on, and I'm going to put May 1st as our marketing day. And the reason that's important is if there was ever a dispute and they go, you didn't market our property on April 18th, 2020. So you didn't click this and you didn't put their property live in MLS on April 18th, 2020. You have breached your contractual obligations at that point. Even if they told you, don't put it live until May 1st. If it's not in writing, statute of frauds. So make sure that you're coordinating with your sellers the date they want marketing to begin. Additionally, say April 30th comes around and they're not going to be ready for May 1st. You need to cross out May 1st and put a new date in, and all parties need to initial. Think of it like counter offers. You need to make sure that anything that changes from the original inception of the contract is changed on the actual contract itself, and all parties initial beside of it. Understand if the delayed marketing date is selected, that the property cannot be shown to any real estate agents. The firm is obligated to present to the seller any offers on the property that may be submitted to the firm prior to the delayed marketing date. And it is in the best interest of most sellers to get the highest possible price on the best terms for their property and maximize exposure to attract all of the offers. So basically what that's saying is, Mr. and Mrs. Seller, I can't show this to any real estate agents, including firms, prior to the delayed marketing date on here. But if for some reason we get an offer on your property before then, I have to present it to you. And, you know, we can accept it still. But I need you to understand, if we do that, that is not in your best interest most of the time to accept an offer before everybody that could be interested has had a chance to see it. Then it says marketing authorization. If you click these, you need to do them. Again, contractual obligations. So signs are going to be put in the yard. Open houses are going to happen. Listing service. So that means that we're going to put it in MLS. Lock boxes on the door. Advertising other than internet. So flyers or anything like that. And then internet advertising. This is where you discuss. Some sellers don't want a sign in their yard. So if they're not, you're going to make sure that that's not checked. They don't want their neighbors to know they're selling. Some sellers are like, no, I don't want a lockbox on my door, and I will have the key for you when showings occur. So you would put, does not authorize the firm to place a lockbox. Some don't want it in MLS. So you're going to unclick that, and then you're going to have them fill out a certification to withhold from MLS. And again, they understand that by doing that, they're not getting the best for their price, but make sure that you're clicking everything that needs to be clicked. It says down here that the property, like the sellers have to understand that the internet advertising that occurs is usually syndicated from the MLS, and that we as the firm have no control over other websites like Zillow having the wrong information, the wrong estimate, any comments that are made about the property on social media that are negative. We don't have any control over that. And this is the disclosure about that to them. So if you get into it and they're like, you didn't do your job because Zillow is showing my house as 3 bedrooms and it's really 4, you can say, Mr. and Mrs. Seller, I've contacted Zillow, but I have no control over their website. Remember our listing agreement that we signed where I disclosed that this could occur and there's not much we could do. It says no, NCAR Form 105 may be used to limit or prohibit internet advertising, and explains how such limitations may or may not be effective. So what that does is it's basically a disclosure from NAR. If they say, we don't want it syndicated to Zillow or something like that. If you're doing coming soon, so you're not supposed to go live until May 1st, but they're going to be ready to roll. Pictures are in on April 25th. And you want to go ahead and let the general public know, hey, we've got this coming soon. If you're thinking of buying a house, don't buy it until you see this one, whatever the case may be. We're going to put it in coming soon. And then it says are or are not attached to this agreement. Yes, they are, because you're going to fill out the coming soon at the same time that you're filling out your listing agreement. Your coming soon forms are also in the all forms drop down menu. And, you know, if you're going to do that, we'll go over it. It says seller acknowledges and understands that while marketing services selected above will facilitate the showing and sale of the property, certain risks are associated with them, including but not limited to, and you know, we'll do everything we can, but some things are beyond our control. So unauthorized use of a lockbox. I can't control if John Smith from ABC Realty does not go in showing time, and you can't hold me liable for that. We can file a complaint against John Smith, but you can't hold me liable. We have no control of the visitors during or after a showing or open house, including the taking of use of photographs and videos in the property. They're not supposed to, but we can't control that. So if John Smith is taking his buyers to the property and they take a picture and the buyers are excited and they put it on their social media, we have no control over that. Inappropriate use of information about the property placed on the internet or furnished to any listing services in the firm that the firm participates in. That goes back up here to internet advertising. We can't control inaccurate information on other websites. It says information about the property placed on the internet by or through any listing services in which the firm participates, which is inaccurate or dated, or information about the property which will remain on the internet following the expiration. So we've all seen it where the listing expires and it's still showing up on, we'll say, homes.com, and you're still showing as the listing agent. There's nothing we could do about that. Seller acknowledges and understands that neither the firm nor its agents have control over information about the property that has been placed on the internet. Guys, this is a big one. There's a reason this keeps popping up, and it's because this is one of the biggest complaints sellers have is, my house wasn't listed right on Coldwell Banker's website. We have no control over that. Then it says, warning, it may be a crime under federal and state laws to listen to or record an oral communication through the use of electronic, mechanical, or other devices without the consent of the party that is happening. So you need to tell your sellers, if you have security systems, ring doorbells, whatever the case may be, that picks up voice, you need to disable those for showings. We are not allowed to listen in on buyers and their conversations with their agents, and you need to make sure that your sellers know that. Earnest money. So unless otherwise provided in the sales contract, an initial and additional earnest money deposits and any other earnest monies paid in connection with the transaction shall be held by the firm in escrow until consummation or termination of the transaction. Any earnest money forfeited by reason of the buyer's default under a sales contract shall be divided equally between the firm and the seller. In no event shall the sum paid to the firm because of a buyer's default be in excess of the fee that would have been due if the sale had closed as contemplated in the sales contract. So, for instance, you know, as EXP does not hold earnest money. Usually the buyer designates an attorney to hold the earnest money. There are some listing firms that require the earnest money be held there, like, you know, Allen Tate, I believe, requires earnest money to be held at their firm. This is just letting the seller know that, hey, if the buyer defaults, we're going to split the money because I work, you work, yay. Seller representations. Is it in a flood zone? So the seller is going to say is not, does not. That's fine if they sound like, if they're 100% sure it's not in a flood zone, great. You still need to verify, because remember, guys, the sellers, we are held to a higher standard than the sellers. So the seller may not know they're in a flood zone, but you as the agent should know that they're in a flood zone. So FEMA flood search maps. And this is just prior to, you know, going live. You're doing some research in the back end. So you type in FEMA flood maps. It's going to ask you for an address, 8230. And again, this is what you print out. So you want to print it out because flood maps can change anytime, and you want to have proof that you did your due diligence. So if you look at 8230 Chilkoot Lane, you will see that this is zone X. That is not a flood zone. It does not require any kind of special hazard flood insurance. But the address itself is 8230. It's this house right here, and you'll know this. and you will see that that is in the blue. That is a zone AE. So you print that out, and then you as the agent should, in agent remarks, be disclosing located in flood zone AE. And you should be going back to your sellers and saying, hey, I know you said you weren't in a flood zone, but I'm pulling your house up as a flood zone. Are you sure? You know, I have to disclose this just to let you know. You come down, synthetic stucco, owners association. So we have owners association. It's Meadow Creek Village HOA. It's, you know, the name and address of the president and the telephone number. We use Cedar Management. We would put all that in there. If it is new construction, and then you don't have to have them fill out the property disclosures. So you would put no. New construction is a home that is being built and has never been lived in, never been occupied whatsoever. I don't care if the house was only occupied 3 months, it is not new construction, and they still have to do the residential property disclosures, and you cannot put it in MLS as new. At the seller's expense, the seller authorizes and directs any owners association or any management company of the owners association to release to the firm true and accurate copies of all things. So architectural guidelines, your account statement, your financials, your CCRs, your articles of incorporation, all of that. This says, hey, my seller authorizes Cedar Management Group to talk to me as their agent. If there is a termite bond, you click is. If there is not, you put not. You'll find that out from the seller. And then, has the property been owned for less than 1 year, at least 1 year, or does the seller not own the property yet? So seller does not own the property yet. A way to think of that is you have an investor and they are in the process of building a house with a contractor and everything, and they're not doing a construction to perm. The builder themselves are footing the bill for it. So right now the builder's name is what's on that address and that property and that house being built. But you are going ahead and getting a listing agreement signed. So what's going to happen is once the builder finishes, the property will convey to your seller, and then your seller is going to have you put it on the market to make profit. That's one example of when does not own the property yet comes into play. So receipt of sample forms, you can get your sample offer to purchase and your professional services disclosure and election form here. How you're going to get the sample copy is you're going to go up to print, and then you're going to put print sample. And so what's going to happen is it's going to have sample written all across, because we can't give out our forms to just anybody. Current liens, if they have a balance owed to their lender, it is encumbered, and you're going to find out who their lender is, the approximate balance of the loan, and phone number and address. This will be utilized for the closing attorney. If they own it outright, you put is not encumbered by. The seller is current on all payments for loans identified, and the seller is not defaulted on any loans identified in any of these. So you notice there's several spots. So if you have a first mortgage, a second mortgage, or a line of credit or something like that, you would put all of those in here. Outstanding liens that may affect proceeds. So if the seller had a contractor come and do work on their house and a mechanic's lien was placed for non-payment, this needs to be disclosed here, because that's going to have to be paid off at closing. Seller is not under bankruptcy protection. It is not contemplating bankruptcy protection. Those are material facts, so they need to be honest about it. Seller represents that the property has legal access to a public right-of-way. If access is by private road, easement, or other, seller further represents that there is or is not an agreement regarding maintenance of a private road. They will know this. If they say, I don't know if we have a private road agreement, then they don't, because they couldn't have got a loan on the house without a private road agreement. Lease. To the best of the seller's knowledge, the property is or is not subject to a lease. So if you're selling a property that has tenants in it, it's going to be subject to a lease. And if it's not, then it is not. If the property is subject to a lease or is not subject to a lease, and it is managed by a property management company, you need to get the manager's name and contact information, because they will need to know as well. FHA appraisal. If you're taking on a listing, you need ask them, has it been FHA appraised in the last 4 months? What that means is they could have been refinancing and an FHA appraiser came out. It could have been under contract with another firm and an FHA appraisal was performed, whatever the case may be. what I will say in this is if you take it on and initially it has not been performed on the property, you go under contract and an FHA appraisal does occur and it comes in low or the contract falls out, you need to come back and fix this and put has, and then all parties need to initial and date. Special assessment. So if there is a special assessment, and I'll give you some examples. The HOA is doing a $5,000 per household special assessment in order to fix the roof. The county is doing a special assessment to each homeowner of $3,000 to connect to city water. Any kind of special assessments are right there. And this says proposed or confirmed. So even if it isn't a for sure thing, your sellers need to know if it's been proposed, you need to disclose it. If you guys are doing a manufactured or mobile home, you need to get the VIN numbers for them. If you have a fuel tank, so if your clients, if you're in the house and you notice a gas stove or you notice a gas fireplace, you need to ask them, is this natural gas or are you propane? If there's propane, you need to know where the propane tank is. And then you need to disclose that there are fuel tanks located on the property. Then find out, do you own that tank or do you lease it? When was the last time it was filled up? All of that fun stuff. Seller's duties, they are agreeing to provide in a timely manner the property disclosures, mineral oil and gas rights, lead-based paint or lead-based paint addendum, provide the firm copies of restrictive covenants, bylaws, articles of incorporation, rules, regulations, title insurance policies, attorneys. Some of these things they won't have and we'll catch them in title, but they need to make a good effort to get that to us. Seller authorizes an attorney presently or previously representing seller to release and disclose any title insurance policy information. The seller is immediately going to refer all inquiries or offers to the firm. So what that means is if their friend John Smith from work wants to, or well, our seller is John Smith, Joe Jones wants to buy this house and he works with them and he gives them an offer, the seller can't cut you out and they can't negotiate and all that stuff. They need to tell you immediately. Seller is representing that they're going to provide a general warranty deed when conveying the property, fee simple marketable title. That means that they can't, you know, we're going to give you this property, but we're still going to retain 10% ownership in it. Seller represents that they have the right to convey the property and there are currently no circumstances that prohibit the seller from conveying marketable title as set forth in the preceding sentence, except for as follows. So if there's any exceptions, that's where you put this. If any sale of the property is a short sale consideration should be given by attaching NCAR Form 104 as an addendum. So if the bank is approving a short sale, you need to put that addendum on there. Home inspections, seller usually is not going to agree for a home inspection, but some people or some agents like to have the home pre-inspected. And in this case, it would put agrees and then pay for a home inspector to come in within so many days of the execution of this agreement. This is, if you guys are going to offer a home inspection for pre-listing, put this here and then come down and put in additional terms, because that is telling the seller that he agreed to have a home inspection done. Seller acknowledges receipt of copy of questions and answers on home inspections. Again, that's in your all forms tab. Photographs and other materials, the seller understands that those are bought for and paid and they belong to the firm. And so if they terminate with you, they can't keep your flyers and pass your photos on to the next agent. And then additional terms and conditions is anything that you feel needs to be said here. If the seller says, I want to list my house at 550. I know you say it's only worth 500. Let's try 550, but we'll reduce if we don't get any bites. Down here, you're going to put seller agrees to reduce to $500,000 per recommendation of the agent if no offers are presented by May 31st. This is that contractual obligation down there for them. Dual agency, we all know dual agency, but you're going to explain dual agency again. You should have done it with working with real estate agents, but you're going to explain it again. And this is where they authorize the firm to act as a dual agent. So what they need to understand is if they are authorizing the firm to act as a dual agent, and they just initial right here, that means that you can represent a buyer and them. If they are like, hey, we want people in your firm to be able to show the property, but we don't want you representing a buyer, then they would initial right here, authorizing dual agency, but then they would initial down at the bottom saying designated option only. If the seller's like, no, I don't want your firm to represent a buyer at all, they need to understand that nobody with the eXp Realty can show their property to any of their clients, and then they would initial right here. They also need to understand, and if they are going to do designated agency and you just pop up and have a buyer that happens to inquire about it, this can always be changed. It just needs to be authorized in writing by both parties prior to an offer being written. Mediation. If a dispute arises, the seller is going to agree to try and negotiate or mediate to settle the dispute. If the need for mediation arises, the parties will choose a mutually acceptable mediator and will share the cost of mediation equally. Wire fraud warning. Nobody is ever going to ask you to send them funds or gift cards or anything like that. Towards the end of the transaction, you may get a request from the closing attorney for wiring information. I always tell my sellers, before you do anything with that, call me and I'll confirm that it's real. Come down, you're gonna have all parties, name, signature, date. It's good to have their contact information and mailing address on here. If it's a corporation, right here is going to be the name of the corporation. So if it was ABC or BAC Construction, you put that in there. By is gonna be whoever the managing member is gonna sign and date. They're gonna print their name and then their title within the corporation, and then put all their information. This is the firm's information, license number for the firm, the office address, the agent's signature, so your signature, your license number, date, and all of that. So you'll notice to make this an executed binding agreement, you're gonna have to have all sellers initial down at the bottom and you initial down at the bottom on every single page, and then the signature page at the end. And once that occurs, you have an agreement. So I'm going to go back for a minute. When you go to a listing appointment, bring your property disclosures and you're going to bring your mineral, oil, and gas rights. Ideally, they should fill those out within 24 hours of execution, because that's going to help you complete the MLS listing. So you come in here, you cannot fill these out for them, but you need to explain to them what yes, no representation means. And you need to explain to them that even if they choose no representation to a leak, and you as an agent know for a fact there is a leak, you have to disclose that. So yes means yes, I know of a problem and I'm going to elaborate down at the bottom. No means nope, absolutely sure there's not a problem, we're good to go. No representation means, you know what, I really don't know if there is or isn't a problem. They need to understand that no representation scares people. So if they are going to put no representation, a lot of people are going to be gun shy, because a lot of people look at that as, oh, they know something, they just don't want to tell us. That's not always the case, but that's how the general population looks at it.
I have a quick question.
Go ahead.
Do you know if any of these forms, like the MOG and the property disclosure, do you know if that's available in Spanish? Or they're all in English?
Let me look. Let's see. So it looks like it's all in English.
Okay.
But what we can do is, after we finish, we can look on the North Carolina Real Estate Commission site, and I can contact one of our broker in charges and ask if there's a way to have the forms in Spanish.
Okay.
I'm sure there's got, I would think there are, but then at the same time, you've got to understand these forms are going in MLS and being signed by your buyers for your listing. So if your buyer doesn't know Spanish, then—
Oh yeah, not the one for them to fill out, but in Spanish so they know what they're filling out, so they understand.
Yeah, gotcha.
But they'll be filling out the English one, just have the Spanish one as a reference that they can you know.
Yes. So I can find out for you for sure. If for some reason there's not, what I would say is go through with them, because you're going to be translating for them.
Right.
Go through with them and explain. You're not filling it out. You're just explaining it. You're translating it. You're not steering them to pick one thing or another. And you're definitely not putting your pen to that paper.
Oh, no, no, no.
So, and that's what you would do right here. Same with the mineral oil and gas. It's asking, you know, hey, did the previous owners do this? And have you done it? Yes, no, no representation. And then yes or no, because if a seller will know if they themselves have severed the rights for minerals, oil, or gas. That's why they don't have an option for no representation there. There's no way for them not to know. So keep in mind, this right here is buyer's initials. Your sellers are not going to do anything on the left-hand side. They're just going on the right-hand side and clicking boxes. And then they are signing where it says owner signature, asserting that they filled this out. So, any questions about the listing agreement?
I think I'm good.
Okay. Real quick, I want to kind of show you in Matrix. So first step, you go to the listing appointment, you do your listing presentation, you get them to sign the exclusive right to list. Yay. First thing you're going to do is you're going to put it in SkySlope and set up a transaction in SkySlope. So let me show you. This will be brief because it's kind of self-explanatory. It walks you through. But when you log into SkySlope, you're going to have the option to manage or create transactions, manage or create listings. If you've done SkySlope training, you know transactions are your buy side, listings are your list side. So you're going to create a listing, and then you're going to click enter, and Sky up there is going to walk you through everything you need. All the information she's asking you is going to be on your listing agreement, which is why I say try to get it filled out as thoroughly as possible. Then comes time for putting it in Matrix. So say you get it signed today and you want to start working on your MLS entry on the 22nd, and you've got disclosures back. You go into your Matrix and you're going to do an add edit. You're going to add a new listing. Single family home, right? You can do this several different ways. You can fill from Realist Tax Search, or you can start with a blank listing. Or if you previously had the listing and it expired and you're doing a new one, you can fill from that MLS number. You cannot fill from someone else's MLS number, only from yours. And then it walks you through adding them. You guys will have, here, let me do an example real quick. So make sure your county is checked if you're going to fill from tax records. And sometimes it'll let you and sometimes it won't, but I just want to get in. So 8230 Chilkoot Lane, and then Hughes. Search. All right, so there it is. I'm going to fill it in. And so what that does is it fills a lot of information in for me already. You're going to do incomplete because you don't want anybody seeing this right now, right? Say you get to the point where you're ready to go coming soon, no show. You would do coming soon, no show and put May 1st because that was the date it was supposed to go live in this box right here. At midnight on May 1st is automatically going to go live. Or say you're ready to throw it active now and it's May 1st and you're ready to go. You're going to click active, marketing date May 1st, and you go to your location information. You'll see tax records filled most of it in. There's going to be some things that you do have to fill in. This is not going to let you submit without all the required information in. What will happen, and I'll see if I can show you, submit listing. See how all these red things popped up? You've got to put that information in. Tax location, you're going to find this on the tax records and Realist. Listing office information, you see it's got to have all this stuff filled in. So you're going to go through, fill it all out. And then when you're ready, you click submit. And it'll put it into, and I'm going to cancel it so I don't actually have it, but it's going to put it into your listings. And so if it is an incomplete listing, it will show under editable listings. If it is under contract, it'll be under contract. If it's active, active, coming soon, coming soon. So just to kind of go over some stuff with you. This is how it's going to look when you put it in. You have to put pictures in MLS. It doesn't have to be a lot. It can be just one, but you got to put pictures in MLS. And as you're doing your first one, if you guys need help, call me, reach out to me, and I can help you with that. So once you get it in MLS, you've got to set up your showing time. So you will notice if you go into your showing time, let me see if I can get logged in. I do not remember my password. Or I could do it in Matrix. Here, let me go to my active listings. We'll do Woodhurst, and you guys can come down, go edit, and then you can see where it says manage showing time. And it's making me log back in. Of course, it's not gonna work because I need it to work. All right, so now you're in your showing time and you're under your listing. This is where you're going to put how the agent's gonna access the home. If it's on a combo box, what the combo is. You're gonna add your owners to here so they can confirm it. And then you're going to share this app with them so that they can log in with their email and phone. This is where you put any showing restrictions, anything like that. If you want as soon as an appointment is confirmed, if you want an attachment of a brochure or something, you can set it from here. So that's your next step. Get it in MLS, get showing time set up. Once your showing time is set up and you're live, you're on the market. A couple of things I do want to say. After you get the listing agreement signed, there are certain things that you need to do in order to get your house on the market. So one, you're going to need to measure it yourself or get it measured professionally. That's going to give you this information. Let me get to this information here. And you cannot submit the listing without this information. So you're going to want to have your measurements. Then you're going to want to schedule your photos, get your sign and your lockbox out. That's literally the 4 things other than putting it in an MLS that you have to do. This will go along with your marketing, what you do for marketing and things like that. So for me, I do professional carpet cleaning. So I would make sure that the carpets are clean prior to pictures. And then you start marketing your listing on social media. You start, checking out any showing requests. What I do, and not everybody does, but if you go into your listing, you can see what agents have clients that this has gone out to. And if their clients liked the property, it'll have a light bulb. If their clients favorited the property, it'll have a heart. You can email those agents directly from here so that they can reach out to their client too. Is there any questions? This is basically listings, from listing presentation, getting things signed, to putting it in MLS.
This is great stuff.
Do you have any questions? Because I think your questions are going to be really valuable to anybody that might watch this in the future.
I think I had a question, but I have to wait to speak with my client to figure out how I'm going to put it in the listing agreement.
Gotcha.
So I guess once I figure out what that question's going to be, depending on what they tell me, I can let you know, and we can find a way of maybe sharing it with everybody else.
Okay. Do you want to tell me what the question would be, and we can just do an example of what we would do if their answer was what we thought it was going to be?
Yeah, let me go back to SIP forms and let's see, because give me just a second.
Take your time. Anybody that's gonna watch this video, I'm sorry for the background noise.
Yes, I'm sorry too. I have my kids here too.
Real life training, right?
Oh yeah. So it was about the fee. If I'm representing the client and helping them buy a home, and then I'm also helping them sell their home, I can offer them, instead of, since the fee can be, instead of charging them 6%, I can say 5%, because
Yeah.
I'm helping them.
Right, and then you would just determine whether you're gonna give the cooperating buyer's agent 3% of that 5, 2.5% of that 5, what you're gonna do.
Okay.
And I would discuss that with your seller. I
Right.
always let my seller know, and I'll give you the exact spiels that I give them right now. Mr. and Mrs. Seller, as a firm, we are charging you 5%. Of that 5%, we offer a portion of that to our buyer's agents. I will say that part of my job is to make sure your house is as marketable as possible. So you need to understand what the implications could be. Although they're not supposed to, there are realtors out there that will still steer their buyer away from your house if you do not offer at least 3%. They're not supposed to do that, and you don't have to offer 3%, but I want you to know the pros and cons. And the way I look at it is, think of it this way: if there are 4 houses for sale in your community, including yours, and 3 of those houses are very similar to yours, and those particular agents are offering buyer's agents 3%, and then the buyer agent comes to your house, they're going to disclose to their client, hey, you're going to have to come to the table with the other 0.05% for my compensation. And most of the time, buyers are going to go to the house where they don't have to bring as much money. So I strongly, strongly recommend of that 5% that we offer a buyer's agent at least 3%. And if you're not comfortable with that, let's discuss why. At the end of the day, you have to do what your seller tells you to do, but you want them to know. The worst thing in the world to do is to discount your commission to 5%, and then you keep 3% and give a buyer's agent 2%. And in the listing agreement, it did not specify that, because then you're in breach of contract. Additionally, you're going to get some side eye from an agent at the closing table when they see you took a full 3% and they took 2%.
Okay, got it.
Also, remember, if you're going to, for double deals, if you're going to discount commission, so like for me, what I do with my clients is, usually someone is selling their home and buying something more expensive. So I will discount my list side commission, but I won't discount my buyer side commission.
Okay.
Any other questions?
Nope, I think that was it.
All right, I'm going to stop the screen share and I'm going to stop recording. Hold on 1 second.